My name is Dr. Ted Bonar. I live in Columbus, Ohio, and I'm the director of End Family Fire at Brady. And I want to thank Doctors for America for putting this great event together. I'm grateful to be a part of this training, and I hope everybody who's participating is getting what they need out of this. And I also want to thank everybody for your patience, as I'm unfortunately not able to be with you live today. So thank you for your patience for watching this brief video. I think we can keep it pretty quick. I've been asked to cover any intersection of laws, regulations, HIPAA regulations, and conversations about firearms with patients. And so we're not going to be going through HIPAA in detail, right? HIPAA is big. And I'm not here to cover the HIPAA law and regulation and act with you today. We will be just staying broad and speaking directly to any confusion or and just setting us on the right path to have a conversation about what any legal obligations we have regarding these conversations about firearms with patients. So one reason that it's so important to have this conversation is there's some confusion out in the world about this. 10 years ago, Florida and then Florida Governor Rick Scott signed into law an act that prohibited physicians from talking about firearms with patients, okay? So because this happened in Florida, and so in other words, because this happened in one state, a lot of questions get out there into the world about is this a federal law? Is this in any other states? What's the status? Are we allowed to ask questions of clients who might be at risk of suicide about firearms? So this is to clear this up. It's very simple. The 11th Circuit struck this law down as unconstitutional, as a violation of First Amendment rights, that physicians are allowed to talk about risk with clients, and that is between the physician and the client, and that law does not exist. So this is really simply to clarify. You can talk to patients about firearms, and that's regardless of the state you live in. There is no language, there's no law, there's no statute, there's no regulation that prohibits any conversation. And in fact, we're obligated to have this conversation ethically when somebody is at risk of suicide or harm to others and might be, right? It is vitally important. You've already heard it today. Can't be repeated enough, that firearm ownership in and of itself is not a risk factor for suicide or harm to others. Millions of people own firearms and they don't think about killing themselves, or they don't think about taking somebody else's life. And for those who do think about suicide or harm to others, access to that firearm dramatically increases the risk of injury or death. So these conversations are legal and they're ethically obligated for physicians or mental health professionals, and there's no law prohibiting those conversations from occurring. Another piece of legislation that's important to acknowledge, simply so that we understand what it does. There was a rule that was added in 2016, and it is an addition to the HIPAA Act. So there's HIPAA that everybody knows, and then there's the National Instant Criminal Background Check System, otherwise known as NICS. NICS is the database where when somebody wants to purchase a firearm, firearm retailers have access to the NICS database, and that's where that's where a retailer will run a background check. So the reporting process to NICS does differ by state, and depending on what state you live in, you can go to this resource at giffords.org. This link should be active, where you can learn about the reporting process in your state. We don't need to go into details on how to report for the purposes of today's presentation. But this rule addition in 2016 essentially said this is how HIPAA allows for providers to provide information to the NICS background system to enter anybody who might be subject to, and this is where we get into this, a mental health prohibitor into the background system, right? So Health and Human Services, right, which is the agency that oversees HIPAA, expressly permits HIPAA-covered entities to disclose to NICS the identities of individuals who are subject to mental health prohibitors, disqualifying them from shipping, transporting, possessing, or receiving a firearm. So you can't purchase a firearm necessarily. So just to understand this a little bit better, and this next slide has the language of the rule itself. So this is not my language, this is the language of the rule. The rule permits, so it doesn't demand, permits reporting to the NICS system individuals who have been involuntarily committed to a mental institution, found incompetent to stand trial by reason of insanity. Again, this is the language of the rule. And there are legal definitions for each of these terms. Have been determined by a court, board, commission, or other authority to be a danger to themselves, or somebody who lacks the mental capacity to contract or manage their own affairs as a result of et cetera, et cetera. So this essentially is what most physicians and mental health providers have been aware of in terms of when can we break confidentiality. And this carve out, this rule, is simply to provide for the easier access to the NICS system when somebody might be at harm to themselves, be at risk of harm to themselves or at risk of harm to somebody else. And this allows us to provide that information into the NICS system specifically, right? And this is a very important piece here. The disclosure is restricted to limited demographic information, and it prohibits the disclosure of diagnostic or clinical information. So the carve-out, this rule carve-out, is designed to protect individuals as well as protect the common good and protect public health. If someone is determined to be at risk of harm to themselves or others, not only are physicians or mental health providers permitted to break confidentiality for the purposes of finding care for those individuals, but information, limited information in terms of demographic information, can be provided to the NICS system as well. So those are essentially the only specific intersections between physicians and clients and discussions of firearms. We are allowed to talk about firearms, and if needed, we are permitted to enter a person's identity and certain demographic information into the NICS system, but we are not allowed to provide clinical or diagnostic information. Now, the next step of this are extreme risk protection orders. And our next section is going to be covering extreme risk protection orders, which vary by state. And we'll be talking about that specifically so you know a little bit more about them, to have some practice and learning the rules and regulations about those. And other than that, the main focus for this intro of this next section is to say you're permitted to talk about firearms with clients. And it is more than important to do so when somebody is at risk for suicide or harm to others and may have access to firearms. So thank you very much again for allowing me to do this by recording. I hope that this has been a worthy use of your time to just clear up some simple and fairly common misunderstandings or thoughts about any regulations that may or may not exist. Thank you again, Doctors for America, and I hope you enjoy the rest of the training.